Well, thank you to everyone who attended or is attending this webinar this afternoon. Like I said at the bottom, we have one coming up, another one coming up on August 6th, and then we have one coming up on July 23rd, I believe, over FSMA. I made this before I knew about the FSMA one, or I would have included it, so we will get those details sent out to everyone with the evaluation after this, hopefully. Yeah, let me see. The only other thing I need to say before I introduce Shannon is I forgot to include in the registration a question if you are a beginning farmer. So could you please take the poll over to the side to tell us if you're a beginning farmer or not, to help the Beginning Farmer Success Program out in collecting some data. And now I will introduce our speaker today. For those that attended the last webinar, we have Shannon doing 3 different webinars with us over different topics, and today's is over ag labor, especially in the I-9 verification process, and then some other federal labor laws to be aware of. Shannon is currently an associate professor in the Oklahoma State Department of Agricultural Economics, where he specializes in agricultural law. He grew up on a cattle and wheat operation in western Oklahoma, or God's country as it is sometimes referred to, and obtained his bachelor's and master's degree in agricultural economics from Oklahoma State before he obtained his Juris Doctorate from Oklahoma City School of Law with endorsements in estate planning and business and financial services. Shannon spent a number of years in private practice focusing on environmental, agricultural, energy, and corporate law before joining OSU in the summer of 2007. As a member of the Department of Agricultural Economics, Shannon holds an extension and teaching appointment. Since joining OSU, he has provided over 300 extension seminars and workshops throughout North America, with a cumulative audience in excess of nearly 19,000, while authoring over 50 extension publications. His extension activities encompass all areas of agricultural law, and he also teaches the agricultural law courses at both Oklahoma State and the University of Oklahoma College of Law. And I will switch us over to Shannon's presentation. Is over to the right that you can download it, and if that doesn't work because of internet issues, please let me know and I will email it to you. So Shannon,
all right. Thank you, Paul. I appreciate that. And first off, I'll also remind everybody, if you have any problems with the PowerPoint animations today, I apologize. I was telling Paul that my system crashed exactly at the point that I was uploading this to the website, so hopefully everything is relatively glitch-free. Also, for those of you that tuned in to our last presentation over farm transitions, I'm going to apologize that this one is a little less graphics intensive, and I haven't really developed the comedic material around this one as thoroughly as I have the farm transitions one. So if anyone has any good I-9 related jokes, please forward them to me at the email address that you'll see at the end of the presentation, and I'll try to make this one a little bit more funny. I-9 is a bigger issue, I think, than most people realize in agriculture, because lots of times agriculture requires large amounts of seasonal labor, which means that you kind of have to get a large amount of employees relatively quickly, and lots of times that may involve immigrant workers that are specifically interested in seasonal labor positions, because that gives them an opportunity to make some money and then return home for the rest of the year. And so that's kind of got some appeal, and it can be mutually advantageous for both parties. But at the same time, over the past few years, we've seen a lot more emphasis on immigration law and immigration issues, particularly as related to homeland security. And so as a result, that's increased the level of scrutiny specifically for employers when it comes to verifying the immigration and work eligibility status of their employees. By the same token, we've seen a lot of state legislation. I know in my home state of Oklahoma, we've had a pretty significant piece of legislation passed that dramatically increased penalties for employers of people that weren't eligible to work in the United States. And so all that just goes to underscore the importance of the I-9 process. And so that's why we're talking about I-9 today, is to give people that work with ag employers or that are ag employers themselves a little bit of a background and kind of a procedure to follow as they're completing the I-9 process with their employees. Now, if you're not already attuned to why the I-9 process is important, I'll just tell you that under several federal laws, it's a crime. I'd like to underline that it's a crime. It's a criminal penalty, not a civil penalty. It's a criminal penalty to knowingly hire someone who is unauthorized to work in the United States. And these penalties are on a graduated scale. Your first offense, if you hire someone that you know is an unauthorized alien, that's going to be at least $275, ranging up to $2,200. The second offense goes from $2,200 to $5,500. And then if you've had more than 2 offenses, you're now looking at up to $11,000. And by the way, when we start talking about that, we're talking about per violation. That means per worker. You're looking at a fine of up to $11,000. And if the Immigrations and Customs Enforcement Agency, ICE, ICE, notices that there's a pattern or a practice of violations, in other words, if you've repeatedly, knowingly solicited or hired people that are not eligible to work in the United States, those fines now go up to $16,000 per violation and up to 6 months imprisonment for each of those violations. So the penalties can get pretty significant pretty fast. And this is something that we've seen in the agricultural sector. Just in the past few years, we've seen some ag employers, and the case I'm thinking of specifically involved a dairy, that had kind of done this as wrong as they could. They had knowingly hired undocumented workers, and they faced a criminal fine of over $3 million by the time they got to all the violations adding up. So, you know, this can run into real money and some real consequences. So this is really important for all of us to consider as we're hiring our agricultural employees. But on the other side of this, what do we get out of the I-9 process? Well, first off, completing I-9 is actually a pretty straightforward process, and we may talk about several steps today, but in the grand scheme of things, the I-9 form really isn't that hard to complete. And once you've done it, you now have a very solid defense against any allegation that you failed to verify the employment that you failed to verify the eligibility of your employee. It gives you an excellent defense if you have any allegations brought against you by a state or federal agency about knowingly hiring an unauthorized alien. And anytime that you're involved in any sort of immigration dispute, the I-9 process and the documentation that you collect as a result of that process are going to be excellent pieces of evidence for your defense when you're trying to show that you took all of the necessary steps to determine the eligibility of the employee that you're talking about. Now, people always ask me, Ferrell, if I do all this, will I not get sued? Will I not get charged? And I would love to tell you that this is a guarantee against that, but you can get sued or charged for lots of things, even if there's really no fundamental basis for that charge. But what this process will do is provide you with the evidentiary pieces that you need to get those allegations or those litigation claims dismissed quickly, because you'll be able to show, hey, I followed all the proper steps to document my employee's eligibility. So with that, one of the first things you have to ask yourself is, who do I need to prepare an I-9 for? And the answer to that question is that you have to prepare an I-9 for any employee that you have. And to take this to the extreme, if I own my own business, if I have an LLC or a corporation, and I make myself an employee of that corporation, I have to complete an I-9 for myself. So all employees, everybody, it doesn't matter if you have 1 employee or 1,000, every employee must have an I-9 documentation prepared. Now, many people ask the question, well, who's an employee? And the factors that we've got listed on this slide aren't the be-all and end-all, okay? Determining whether someone is an employee or an independent contractor is kind of a fact-intensive examination that's going to be done on a case-by-case basis. But these factors are some of the factors that you consider when you're determining whether someone's an employee or if they're an independent contractor. Now, if someone is an independent contractor, truly an independent contractor, we don't have to have an I-9 form for them. Their I-9 concerns are their own. We just have to worry about employees. And of course, employees are people that we can control, people that we can give very specific instructions to about how and when they do what they're supposed to do. We tell them how to do that in terms of which tools to use, and by the way, we probably also provide those tools to them. We supervise their training, instruction, evaluation process, and they're going to get paid no matter what the outcome of what they're working on. So they don't really have a financial risk in the outcome of the work they're going to be paid if they perform the work. On the other hand, an independent contractor is probably what you kind of think of when we're talking about an independent contractor, and specifically when we're talking about people that are engaged in agricultural work. Many times there will be a contractor that will assemble a labor force and contract it to an agricultural employer. So if you go to a labor broker service, for example, and say, hey, I need 10 workers to help me hand harvest this specialty crop, they might provide those workers for you. They might provide payroll services. They might provide supervisors. And you're basically contracting with them just to do the work, but you don't have direct supervision over those employees. You don't directly handle payroll services. That looks more like an independent contractor relationship. If you are engaging someone and you just tell them that you want an outcome without being very specific about how to achieve that outcome, if you think about building a house, for example, and you say, hey, I want someone to come in and do the cabinetry work. I just want it to look like this. I don't care how you do it. Well, that looks a little bit more like an independent contractor. Someone who provides their own tools and equipment, someone that you don't train because you assume that they've already got the skills that they need, and someone who has financial risk based on the outcome of the project. You know, if these milestones are achieved, you get paid. If not, you fix the project until they are achieved, and then and only then do you get paid. Those are all things that kind of look like an independent contractor. Now, a word of warning in agriculture. In agriculture, we tend to have a bias towards thinking everyone is an independent contractor, and that is not necessarily the case. Again, go back and look to these factors, and I would just tell you that overall, the more specific the control over the person performing the work, the more they look like an employee. The less specific the control, the more detached that they are, the more independent they are. Those are all factors that kind of go towards someone looking like an independent contractor. And again, as we said earlier, if we're talking about a true independent contractor, then we don't need to perform I-9 for the independent contractor. The contractor is going to be responsible for performing I-9 for anyone who works for them. And so that's the difference right there. When should you complete the I-9 process? And this may seem like a pretty straightforward question, but it's not, because sometimes we want to do the I-9 process too soon in the employment relationship, and that can actually give rise to lots of risk with respect to discrimination issues. So, when should we complete the I-9 process with an employee? After we've made a bona fide offer of employment. And when I say that, what I mean is we've completed the interview and selection process. We've given this person an offer that says, yes, I want you to come work for me, show up on Monday. And in that case, if someone does show up on Monday to start work, then that's the date of hire, and really that's the point at which we should form the I-9 with the employee. Now, once that person has shown up for work, we have a clock started. We've got 3 business days to complete the I-9 process. And like we said, that's when the person has actually shown up, prepared, and ready to engage in work for wages or some other form of compensation. And so the example that you'll see frequently is that if someone shows up on Monday, we've got Monday, Tuesday, Wednesday, and we need for sure to have that form completed on or before Thursday. Now, it is possible that you could make an offer of employment and the person completes I-9 before they show up to actually start work. But again, that creates some discriminatory risk that we'll talk about a little bit later in the webinar. And so what I tell most people is first thing on the first day of work. And if you think about the jobs that you have started on, I'm betting that on the first day that you showed up, you went to the HR office and you started filling out your W-2s, you probably filled out your I-9, and really did all of that. So that's really what we're shooting for. That first day of work is probably the most opportune time to actually fill out the I-9 form. Oh, real quickly, I noticed that over in the chat box we had a question for a specific example of a farm-related independent contractor. 2 examples kind of jump to mind here. Number one is the example we kind of alluded to. In the example of someone that needs to hire seasonal labor, lots of times there will be labor contractors that will engage with the farm to say, hey, you need a workforce of X number of people to harvest this crop. if you contract with me, I'll provide you a workforce that I can guarantee has the skills that you need, that can complete the job in a timely manner, and they will enter a contract with the farm. The farm will pay the labor contractor for the harvest of the crop, and then the contractor, in turn, provides payroll services to the laborers. The independent contractor maintains the documentation of worker eligibility for all their workers. And so that would be a case in which the farmer wouldn't need to complete I-9 for each of the independent contractor's laborers. Another example you could give could be a custom harvester or custom cultivator, where you say, I just need this field harvested, or I need this field cultivated. And if you are engaging in a true kind of hands-off approach, you just specify an outcome. I just need this operation performed. I don't care how you do it. Okay, that would be an independent contractor relationship. But that is one area where we could get into a lot of gray with respect to the I-9 process. And I'm going to rely on an Oklahoma example that's very top of mind right now. In Oklahoma, we're in the middle of wheat harvest. And so if I hired a custom wheat harvester crew to come in and harvest my wheat, and I said, hey, here's 640 acres of wheat, I need it combined. And that's basically what you specify. You agree to a contract price. They go in, they harvest the field. You're not there overseeing them. You're not providing specific directions about how it's to be cut. You just provide very general guidelines. That's an independent contractor relationship. But the more input I have, the more direction I provide, the more control I have over how they do that, then it starts to look much less like an independent contractor relationship and more like an employee-employer relationship. And if that's the case, then I need to be completing the I-9 process for all the people that are my employees. And I would also add another practice note on that, that lots of times in agriculture, people will claim to have an independent contractor relationship when it walks like a employee, quacks like an employee, acts like an employee. And you can't use an independent contractor relationship to willingly bury your head in the sand, so to speak, if you've got reason to know, or you actually do know, that you've got undocumented workers engaged in the process. That's a recipe for ICE enforcement right there. So, very good question on the independent contractor front. One quick thing back to when we should complete an I-9 for someone. If someone has worked for us and then no longer works for us, but then comes back, in other words, if we've rehired someone, first off, if that rehiring takes place within 3 years of when we completed the first I-9 for that employee, we don't have to complete a new I-9. The asterisk to that is that if in the process of completing that initial I-9, we accepted documents that had an expiration date, and some work visas, for example, will have an expiration date, and that expiration date is now passed, we need to go to one section of that I-9, section 3, where we have to make a note of that. But we'll talk about that here in a little bit. All we have to know right now is that if we're rehiring someone within 3 years of that initial I-9 completion, we don't have to complete a new I-9 for that person. Also, if someone doesn't work for us for a time, that doesn't really count as a separation if they do so in what would be considered the course of continuing employment, which sounds like another one of those lawyer words. But when we talk about continuing employment can have breaks. For example, if the break in that employment was simply due to the fact that we didn't have enough work for that person to perform, and they were basically temporarily laid off, that doesn't count as an employment break. If their employment is by nature seasonal, so lots of agricultural work is very much seasonal work because we're either engaged in cultivation that comes along periodically, or we're engaged in harvest operations that come along periodically. That counts as seasonal employment, and we consider those employees, if we've got an employment relationship, to be continuous as long as they're making those continuous cycles of employment. And then if someone has illness or disability leave for either themselves or a family member, that's not considered a break in the employment relationship either. Now, when you go to fill out Form I-9, I always recommend that you go to the website uscis.gov and download the most current form, because occasionally the form will change, and you always want to make sure that you're using the current form. So anytime you have a new employee, I would just go to uscis.gov, go to the forms link, which you can see highlighted by the arrow there in your screen, download the most current I-9 form, and that will save you a little bit of hassle right there. Now, as you're going through the I-9 process, there are basically 3 sections to the I-9 form, and what we're going to do is work through each of those sections. Section 1 of the form is to be completed by the employee. Now, if the employee can't complete the form by themselves, if they need translation services, if they need reading assistance, that's permissible, that's allowed. The person helping them is going to have to certify that they did help the employee and that to the best of their knowledge, all the information provided is true and correct. Now, Section 2 of the form, that's completed by the employer. Okay, so an easy way to remember this, Section 1 is completed by the employee. Section 2 is basically the verification of that information by the employer. And Section 3 of the I-9 is basically reserved for changes or subsequent amendments that need to be made to that information. Also, people often think that they need to submit the Form I-9 to someone, and it's actually the opposite. Section I-9 must be retained by the employer. And the reason for this is that Section I-9 is basically a form of documentation to assist the employer in the event that there's an inspection of the place of employment by Immigration and Customs Enforcement. So don't submit Form I-9 to anyone. You're basically going to keep I-9 as part of your personnel records and make those Forms I-9 available in the event that there is an inspection. This is what the front side of Form I-9 looks like, and I know that's probably pretty small on your screen. Don't worry, we're going to break this up into sections and kind of walk through each section as the webinar goes along. But that's what Form I-9 looks like, and it's actually relatively straightforward. By the way, Form I-9 is available as a downloadable PDF form, so you can fill it out on your computer and just have the have the employee complete their portion. You, as the employer, can complete your portion, print it out, have it signed, and then scan it to records, or you can allow for electronic signatures in certain circumstances as well. So here's Section 1. This is where the employee is basically including information about themselves, last name, first name, any other names or aliases that they use, their address information, date of birth, and if they've been issued a Social Security number, they can provide it here, along with some other contact information. This part's pretty straightforward. This is the employee's certification, and this is the part that kind of gives the application its legal teeth. I am aware that federal law provides for imprisonment and/or fines for false statements or use of false documents in connection with the completion of this form. I attest under penalty of perjury that I am either a citizen of the U.S., a non-citizen national, lawful permanent resident, or an alien authorized to work under a specific work visa or other document, and you'll note there that the expiration date of that document has to be provided. There are other forms of documentation there, alien registration, a Form I-94, which is used in some certain circumstances for asylees or refugees, passport numbers, and then the signature of the employee. So this is basically the employee providing information about themselves and self-certifying that they are employment eligible in the United States. And like we said, under penalty of perjury. There are criminal penalties if it's found that someone has deliberately falsified information for this part of the form. So this is the part that's provided by the employee, and like we said, can be given some assistance, but the person providing that assistance also has to add their certification later on. And you'll see that at the bottom of Section 1. This is where the person that's provided that kind of assistance has to certify that they provided that assistance and they are stating to the best of their knowledge all the information provided is true. By that same token, if someone providing assistance knowingly falsifies information or knows that the employee has falsified information, they are under penalty of perjury if they've signed this certification. Now, Section 2. Section 2 is where the employer has to kind of do their work. Whenever the employee provides their information, they're also supposed to substantiate that information by providing documentation of such. And that documentation comes from what we call List A, List B, and List C documents. And the employer is supposed to examine those documents and record the information about those documents in this part of the form. So as you can see on the screen, there's the title of the document that was provided. So for example, passport, state-issued driver's license, green card. The issuing authority, so if we're talking about a driver's license, state of Maryland, the document number, and all of those forms of documents will have a document identification number. And then if there is an expiration date for the document, that needs to be provided too. So let's talk a little bit about this documentation. These are the lists A, B, and C. Now, as we'll talk about a little bit later on, these are the documents that are considered acceptable forms of identification for the I-9 process. And so if you look at list A, you see that the title is Documents that Establish Both Identity and Employment Authorization. So these are kind of the gold standard documents. If you have any one of these documents, then they establish not only who you are, but they also establish the fact that you are eligible to work in the United States. And the classic example of this is the document that's listed first there. That's a U.S. passport or a U.S. passport card. So if someone has a U.S. passport, that's all they need to show. That documents both identity and employment authorization. You go to list B, those are documents that establish who you are, but not necessarily that you're able to work in the United States. And again, the classic example is the first document listed right there, a state-issued driver's license or ID card that has a photo. So, photo with information such as name, date of birth, gender, height, eye color, address. In other words, it gives you a means of determining that the person giving you the document is who they say they are. List C are documents that don't necessarily help you identify who that person is, but it does document that that person is eligible to work. And again, classic example is document number 1, Social Security number, or Social Security card. And if you think about list B and list C for just a second, your driver's license will help someone figure out who you are. Your Social Security card will help someone figure out that you're eligible to work. But your Social Security card doesn't have your name, or sorry, it doesn't have your photo on it. It doesn't have a physical description of you, like your height, your weight, your eye color, your hair color. So that's why we require a combination of list B and list C documents, is that you need to identify the person as the person in front of you and that they have employment eligibility. So remember to keep these lists separate in your mind. List A is different from list B, which is also different from list C. So when you're engaging in document review with the employee and you're trying to determine if this person is eligible, then you've got to examine these documents as provided in the procedure. And the procedure is one document from list A. So if someone, for example, says we provide you a U.S. passport, that's all you need. One document from list A, done. Absent a list A document, though, we have to provide one document from list B and one document from list C. And I want to be very clear about that. One and only one document. You can't require an employee to provide more than one list B document or more than one list C. The procedures are very clear. Any document from list B will work, but it must also be combined with any one document from list C. So we got to have one from B and one from C. Now, if you're enrolled in the E-Verify system, and we'll talk about E-Verify a little bit later in the webinar, but E-Verify employers looking at list B documents have to have a list B document that has a photo ID. And so that's at least one way in which you can be a little bit more particular about which list B documents you'll accept. You can only accept list B documents that have a photograph. And like we said, you can't require multiple documents from each list, and you can't pick which document. The employee gets to pick which document they accept. People really get worried about their role in verifying the employment documents, and that's understandably so, because we've all heard stories about falsified Social Security cards, fake driver's licenses, etc., etc. And so people are kind of necessarily nervous to think, hey, well, what if ICE comes and inspects my records and they don't think I did a thorough enough job in inspecting this document and it turns out that it was fake after all? Well, the good news is that you don't have to be a document examination expert. In other words, you don't have to be a forensic scientist when you're looking at these documents. You basically just need to use your eyeball and good old-fashioned judgment. The rule is that when someone gives you a document from list A, list B, or list C, what you have to ask yourself is, number one, does the document reasonably appear genuine? And that is to say, when you look at the document, would the ordinary average person on the street look at it and go, yep, that's a real driver's license, or that's a real Social Security card? If it looks real, then you get credit for that, because you're not a document examination expert, you're an agricultural employer, and you're just doing the best that you can. So does the document reasonably appear real? And then, does it reasonably appear to relate to the person presenting it? In other words, does the identification information on the document appear to line up with the person that's handing it to you? And classically, we really deal with that when we're talking about photo-based ID. If the person giving you the document doesn't look anything like the person on the document, well then, that should probably raise a few red flags. But again, if I told you that my name was Shannon Ferrell and you knew nothing about me, you might think Shannon Ferrell was a girl, because Shannon's typically a more common girl's name than it is a guy's name, something I've dealt with all my life. So when we're talking about reasonably appear, in other words, is it more likely than not that the person giving you this document is indeed the person that the document identifies? So, for example, if you see something that looks like this, you would say, well, this document does not appear to be reasonably genuine. That does not really look like what a Social Security card is supposed to look like. So you should probably reject that document out of hand, and you should probably no longer retain that employee because they've provided you a falsified document. But also note, remember, we're doing the I-9 form on the first day of employment, or at least the first 3 days of employment, so this hasn't interfered with our ability to have any sort of defense against discrimination claims. We gave the person an offer of employment, and then when we asked to verify their eligibility, we got a falsified document. We're then legally okay to let that person go. Then we take a look at this, and you know, it might actually look like this was a real driver's license. If you have a plastic card that doesn't appear to have been physically modified in any way, it looks that it's actually a genuine driver's license, okay. Now, when you look at this, though, you might think, this person's name is McLovin. They only have one name. It's a pretty unusual name. That kind of raises some red flags for me. But remember, that's not going to the genuineness of the document. That's going to, does this document reasonably appear to relate to the person giving it to me? So from the standpoint of, is the document genuine, and if this looks like a genuine driver's license, we kind of move past that and then say, okay, can I ask some follow-up questions to make sure that the person giving it to me really is this person named McLovin here? If we want to talk about the ability of the document to reasonably relate to the person presenting it, and I was just telling Paul before the webinar that I'm really not good at making fake IDs. But if someone gave you a Maryland driver's license and it looked like this, and if you'll notice there, this is a document apparently for Mr. Matt Wieters, who lives at 333 West Camden Street in Baltimore, Maryland. He is 6'5" and weighs 230. Now, if the person handing this to you does have brown hair, and the person in this picture does have brown hair, and if the person handing it to you does have blue eyes, and the guy in the picture does have blue eyes, and if that person appears to weigh 230 pounds, and the guy that is identified on here weighs 230 pounds, so far so good. I mean, the person does appear to relate to the document. But you'll notice there that the height is 6'5", and the person that handed you this card is 5'10". Well, now you've got a flag raised, and you say, well, this document says that you're much taller than you actually are. Why the discrepancy? For example, I'm probably my ideal weight if I was about half a foot taller, right? So that's an opportunity to ask some questions there. And by the way, for those of you that are Baltimore Orioles fans, you'll know that Matt Wieters is actually one of your catchers. And is definitely way more athletic than me, the guy in the picture there. Yes, we both have blue eyes. Yes, we both have brown hair, but that's pretty much where the similarities end. I mean, we do both like baseball, but he's a little bit better at it than I am. So that's what we're talking about when we say, does the document reasonably appear to relate to the person presenting it? In other words, does the description and the picture of the person match with the person that's presenting it to you, okay? And if they don't match up, that's where we need to ask some additional follow-up questions and maybe make sure that we're actually getting an authentic document. We mentioned E-Verify a few minutes ago, and E-Verify is a new, well, I say new, it's been around for a few years, but a relatively new system. And what E-Verify does is it enables you to basically have a hand in completing the I-9 process. As you get the documents from the employee to examine, let's say, for example, you get a Social Security card or a state-issued driver's license. You can log on to the E-Verify system, enter the document information, the document number, expiration date, etc., and within a few seconds get verification from the E-Verify database that yes, that is a state-issued document, and yes, the person identified on it is eligible to work in the United States. It's not mandatory for most employers, but it's free, which is very nice. And its advantages is, again, you get another layer of protection for yourself. You can say, in the event of any sort of enforcement action, hey, I got the documents from this person. They looked genuine. They looked like they were related to the person that gave them to me. And I went to the E-Verify system, entered them. E-Verify confirmed that those documents were genuine and that that person was eligible to work here. So what else would you like me to do, ICE? That's the best I can do. And the other advantage of E-Verify is that you get that verification very rapidly, so you don't have to wait for weeks or months to get the information back. Most E-Verify queries actually come back very quickly. As a matter of fact, and I know this may shock you when you're talking about government programs, but E-Verify actually has one of the highest customer service ratings for any electronic document retrieval system, which, you know, again, it's a federal program. That's kind of surprising, but it actually does work. Another really important element as you're examining documents and just going through the I-9 process in general with your agricultural employees is to be consistent. Don't have one set of standards for some employees and another set of standards for other employees. Be as consistent as possible when you're going through the I-9 process with each prospective employee. So, for example, if you make a copy of the documents that an employee provides when they're filling out the I-9 process, then you better do that for every employee that goes through the I-9 process. Doing it for some and not doing it for others raises the specter of discrimination, and you just don't need that. So again, be very consistent with everyone. And to help with that consistency, have a company policy and procedure so that whenever you're taking in a new employee, the exact same steps are taken with each new employee. The more consistent we can be in the handling and treatment of those employees, the more of a defense that we have against any form of discrimination claims, and basically the less risk we have of discrimination, period. Also, to kind of go along with that, make sure only employees that have been trained in those company policies and procedures intake new employees and take them through the I-9 process. Having someone just do this, really quickly because, hey, it's our busy time of the year, we can't spare the people to do this, so, Timmy, go help the new employee go through the I-9 process. That kind of invites us to have those inconsistencies that give rise to discrimination or documentation problems, and we just don't need that. So make sure the people that do the I-9 process with your new employees are trained in how to do it. One thing that pops up a lot in the I-9 process in the context of the discriminatory issues is what's called document abuse. And the Immigration and Naturalization Act specifically prohibits that sort of thing. So what is document abuse? Well, one example of that is when you require someone to provide more documents than required. Remember, one document from List A or one from List B and one from List C. Requiring an employee to provide 2 or 3 or 4 List B documents or 2 or 3 or 4 List C documents, that's not I-9 procedure. That's document abuse that gives rise to a claim of discrimination under the Immigration and Naturalization Act. Improperly requesting employees produce a particular document. I don't want to see a alien registration card. I only want to see a state-issued driver's license. You can't do that. Any List B document, any List C document will work no matter what they are. You can't pick and choose which documents you're going to take. Improperly rejecting documents that reasonably appear genuine and to relate to the employee presenting them. If the document appears genuine, if it looks to relate to the person giving it to you, that's good enough, okay? If you reject it without some form of basis for not believing that that document is genuine, that increases the risk of a discrimination claim. And then lastly, improperly treating groups of applicants differently when completing Form I-9. That's exactly what we just talked about. And I could use myself as a classic example. I am as classically a white Anglo-Saxon Protestant person as you could possibly be. And so if you treat me differently from someone who, quote, looks different, you're inviting a discrimination claim. Treat everyone consistently, no matter what their name is, no matter which dialect they may use. Treat everyone consistently, or you run the risk of running those discrimination claims, and that's kind of running counter to the I-9 process. Once all this has been completed by the employer, you've examined the documents, the document appears to be genuine, it appears to relate to the person giving it to you, you've got a List A document, or you've got a List B and a List C document, then the employer has to complete the certification, in which case you say, I've examined the documentation, I believe it to be genuine, I believe it relates to this person, and the person is authorized to work here. You complete this information and include the employee's first day of employment. That day of employment is going to be important to us because it defines how long we have to keep the document, and we'll talk about that here in just a minute. But this is your certification, again, under penalty of perjury, so you can't knowingly take in someone who's not eligible to work, or otherwise you're going to run into those criminal penalties as well, both as the employer and as someone falsifying the employment documentation. Section 3, we alluded to a little bit earlier. If we need to re-verify an employee, for example, if they've been separated from us, not in the course of continuous employment, meaning they actually have had a complete permanent separation from our operation, but are then later rehired, we use this to re-verify that person. Also, if someone has had a document that expires and they've now got a new work documentation document, we have to include that new updated information here. Also, if someone has had a name change, that's something else that we can document here as well. We've kind of talked about most of these items. Work documentation's expired, name is changed. There is one particularly sticky issue that we do need to talk about in the context of Section 3 re-verification, and that is when someone has applied for employment under a falsified identity. If someone has secured employment, completed an I-9 form with us, and then it's later found out that they did so under an assumed or false identity, but they are now documented and eligible to work in the United States, we need to record that in Section 3. Note, if someone, and this is what kind of bends some people's minds, if they have applied for and secured employment under a false identity, but now actually do have legal authorization to work under their actual identity, they do not have to be terminated. And some people find that a little bit perplexing. They don't have to be terminated. Now, you might have employment procedures that say if you obtain employment under false identification or information, that's a fireable offense, then you are within your rights to fire that employee. But again, we come back to the issue of being consistent with how they handle those employees. So, if you're going to fire one person for securing employment under a false identity, you better fire everybody who secured employment under a false identity. Don't treat one person differently than the others. Again, that's begging for a discrimination claim. So remember, have those policies be consistent. Now, a minute ago we talked about keeping your I-9 forms and how long we have to retain them. How long you have to keep them is defined on the person's date of employment and how long they worked for you. You have to keep a person's I-9 form for 3 years after the date their employment begins or 1 year after their employment is terminated. The longer of those two periods. So let's say someone is hired by you, works for you for a year, and then quits. Okay, they only worked for us for a year. Well, we still have to retain their I-9 form for 3 years from that date they began employment. So even if that's 2 years after they've been fired or they've left of their own accord, we still have to keep the employment information, that I-9 form, for 3 years. Let's say someone is hired by us and works for us for 5 years. They've worked for us for 5 years, they then quit. Well, we still have to keep that I-9 form for an additional year after they've quit. So in that particular case, we've kept that form for 6 years. So just remember, the longer of the two periods, either 3 years from the date they were hired or a year after they have terminated their employment, whichever of those two terms is longer. Now, you can keep I-9 in virtually any kind of format. Many people keep them in hard copy. They keep the original document, and that's fine. They can also use electronic document storage. That's fine too. Basically, you can use any form of storage so long as you can keep the document for the required period of time, you can retrieve it quickly when required, and you can prove that the document won't be tampered with. So let's talk about electronic storage for a second, because that's been catching on pretty quickly in lots of employment settings for the reason that you don't have the mess of keeping around paper forms. You can keep them off-site to make sure that if something happens to your facility, those documents are still retained somewhere else safely, and so on and so on. If you're going to use an electronic storage system, and first off, there are lots of off-the-shelf systems you can use, just make sure that system number one is restricted access. In other words, if only specific personnel have access to those records, and that's more of a security feature to make sure that those documents don't get modified. 2, that you've got backup and recovery of the records to protect against loss. Here in Oklahoma, we deal with earthquakes, wildfires, tornadoes, you name it. Lots of things that could cause the absolute destruction of our record systems. And so what we need to do is, if we have an electronic storage system, we need to make sure that there is some sort of backup somewhere that we can access in the event that the primary records are destroyed. So that might be in the form of a cloud storage system, or you might simply back them up to a CD or USB drive and make sure that that backup CD or USB drive is stored off-site, so that if we have the destruction of the primary records, it doesn't also destroy the backup. Number 3, make sure that employees are trained to minimize the risk of unauthorized access or accidental alteration or erasure of records. In other words, people need to understand that these records are sensitive and that they need to be restricted in terms of who can access them. And they also need to make sure that they're not accidentally erased, which can sometimes happen with employee records as well. 4th and finally, you need to make sure that the system has a way to make sure that there's a record of who accessed the records, when they accessed them, and if any changes were made. That way, if there is some sort of an enforcement action down the road, we can go back, see when the documents were accessed, and see if any unauthorized changes were made to those documents. That can be very important in the course of an enforcement action. We've made lots of references to discrimination issues. And discrimination issues can arise from a number of federal and state laws. We'll talk about just a few of those here very quickly. Like we said, the Immigration and Nationality Act prohibits discrimination for employment based on citizenship or immigration status, prohibits discrimination based on national origin, prohibits unfair documentary practices, which we've kind of already talked about in the form of I-9 document abuse, and also prohibits retaliation. If someone makes a claim of discrimination, that person cannot then be fired because they made an allegation. And we're actually dealing with that in my home state right now, where someone made a claim of discriminatory treatment and then was immediately dismissed. That is a classic example of retaliation. Classic example of retaliation. So just be on guard against those issues. And ways to protect yourself about those discrimination claims are basically a series of don'ts. For example, don't have different eligibility verification standards for different employees. Like we said, have a clear, consistent policy that's followed by everyone that goes through your hiring process. Don't treat different prospects differently. Don't request employment eligibility verification documents before hiring. And many people say, well, why not? I mean, shouldn't I not waste the time interviewing someone if I already know that they're not eligible to be employed? Which is a rational argument, and it does make sense. But the danger is that when we see those employment documents, we're exposed to information against which we might have a bias before we make the hiring decision, and that makes it much more likely to see the introduction of that bias into the hiring process. The alternative, the best practice, is to only see those documents after an offer of employment has been made. So we've engaged in an interview with the employee, we've got information that's actually relevant to their ability to perform the job, and then and only then, after we've made the offer, do we actually get exposed to information that would provide the potential bias. Don't refuse to hire someone because an employment document has an expiration date. This is classically the example with work visas. Work visas have an expiration date, and many people don't hire those with work visas because they think, well, I'm just going to go to the trouble of training this person, getting them indoctrinated to my system, and then I'm going to have to, lose them because their document has an expiration date. Well, that's employment discrimination too, because those documents in some cases could be renewed, or it might just be a convenient excuse for us not to hire somebody that we don't like based on a national origin claim, citizenship claim, or something like that. So refusing to hire someone because their employment verification document has an expiration date is a definite no-no. Don't limit jobs to U.S. citizens unless U.S. citizenship is legally required for the job. And if we're honest with ourselves, most agricultural jobs don't require U.S. citizenship. Generally, the only time you run into that requirement is if you're talking about certain government jobs that require certain clearances or certain legal obligations, and we just don't see that in most of the businesses that we're talking about with respect to agriculture. So, as you're going through the employee interview process, just remember, I-9 has no place in the interview process. It's only to be completed on that day the employee shows up to actually work, after the offer of employment's been made. So remember, no I-9 stuff during the interview process. And since we're talking about discriminatory issues in interviews, let's also kind of highlight some best practices there. You could ask whether an employee is eligible to work in the United States during the interview process, but that's going down a very slippery slope. So my advice is just to not ask anything about employment eligibility until we're filling out the I-9 after an offer of employment's been made. If we find out in the course of that process that the person is not legally allowed to work in the United States, we don't have to honor the offer of employment. That person can be let go if they're not eligible to work. As a matter of fact, they have to be let go because we can't legally retain them as an employee. But do that after the interview process. During the course of the interview process, don't ask any questions about national origin or citizenship status. Again, in 99.9% of agricultural cases, that's not relevant to the actual requirements to do the job, so just don't even ask about it. Don't ask cultural questions. What kind of holidays do you and your family celebrate? What's your favorite kind of meal? Anything that people would do to try to circumvent the process and try to get at national origin or citizenship, that's just dangerous. Don't do it. Even if it's small talk, it may seem innocuous, but it can really have some negative impacts. The do to remember is keep questions focused on what's required for the job. The more tightly linked your interview questions are to the actual requirements of the job, the better your protection as an employer is. So keep the questions to things that help you determine, can this person do the kind of tasks that they need to do for the kind of job that I'm hiring them for? This doesn't really relate to the I-9 process per se, but I just want to remind everybody that when you do hire someone to work after they've completed the I-9 process, regardless of their citizenship or employment status, if they're legally entitled to work in the United States, they're subject to all of the protections of our labor laws. That includes the Fair Labor Standards Act, which deals with minimum wage and overtime requirements, and I would just caution people that there are a ton of exceptions and different rules in agriculture under the Fair Labor Standards Act. So get a good employment law reference material set to help you understand what the requirements for your agricultural employees are under the Fair Labor Standards Act. Just remember, someone involved in agriculture, regardless of their immigration or eligibility documentation, they're subject to the protections of the FLSA. Same thing under the Civil Rights Act of 1964, the Americans with Disabilities Act, the Age Discrimination and Employment Act, the Equal Pay Act, all of those things apply as well. So make sure that you have good employment procedures that keep you on guard against any of the potential issues that could arise with national origin or employment eligibility discrimination there. One quick note too about the Americans with Disabilities Act and employment verification in agriculture. We can't ask questions about medical conditions or past injuries. What we can ask is, are you physically capable of performing the tasks that are required in this job? And we can have a listing of what those physical tasks are. Just make sure that those are actually the physical tasks that are required. Don't ask if someone can lift a 50-pound feed sack over their head if they're going to be in a clerical position. Okay? If someone's going to be required to lift heavy objects over their head as part of their job, you can ask them, can they do that? And you can even ask them to physically demonstrate that. That's okay, so long as it's a bona fide requirement of the actual position they're going to take. But if it's not linked to that position, it just looks discriminatory, and it's going to get us in trouble. Lots of people get very paranoid about discrimination issues, and sometimes they mistakenly think that means that they cannot fire an employee if they're worried that there might be a discriminatory claim. That's not the case. Discrimination is different treatment based on a protected characteristic. So if I fire someone or I refuse to hire someone because of their national origin, employment eligibility mechanism, or anything like that, that's discrimination. But, you know, classic example here, you're fired, you Canadian jerk. Well, if you fired someone because they're Canadian, that's national origin discrimination. Can't do that. But you're fired, you incompetent, dangerous jerk who happens to be Canadian. That's very different. If I'm firing someone because they can't do their job, or they're being a danger to others, or they're creating a hostile environment for other employees, that's perfectly fine. We can fire someone who's not doing their job. That's perfectly acceptable. What we just have to do is to make sure that we can appropriately document that we fired that person because of poor job performance and not because of a protected characteristic. One way to protect yourself against that is to have regularly scheduled employee evaluations that are well documented in writing. So if you've got a history of behavior with respect to an employee that shows they're not doing their job well, they're creating a negative environment for other employees, you've shown that over time, you've pointed it out to the employee, you've given them a chance to correct the behavior, and if they haven't corrected it, now you've got a basis for termination of that employee. But if I just do that on an ad hoc basis, I really run the risk of a counter allegation that I did that for discriminatory purposes and not for a bona fide reason. So, if you're going to fire an employee, fire them for a good documented reason. If someone is unable to do their job well, if they are a danger to themselves or others, fire them. Just remember, you're going to have to fire everybody who's dangerous or bad at their job. Be consistent. If you've got nothing else out of this presentation, remember, consistency is a huge piece of the puzzle here. Always have good documentation that's clear, written, and has been shared with the employee, giving them a chance to correct their behavior so that you can handle that. Now, one thing I will say is that if an employee is providing a safety risk, if they are creating a danger of harm to others, my advice as an attorney is terminate them immediately. And if we have to deal with the problem of documentation later, fine. But I would much rather deal with the problems of facing a discrimination claim that's a purely civil issue versus dealing with a claim that arises out of the death or serious injury of an employee because we retained a dangerous employee. That's just a balance not even worth thinking about. If there is a dangerous situation, let the employee go immediately. Worry about handling the other issues later on. Safety is always first. We'll deal with civil claims later. That, my friends, is the I-9 process in 1 hour. It's a one-page, two-sided form that's pretty straightforward, but it's very important and provides a lot of protections for employers if done right. I know we've used up the 1 hour that we had scheduled for the webinar, but does anybody have any questions really quickly? If you do so, Just use those in your chat window. We'll try to answer a few of those real quickly. In the meantime, if you have questions or issues you'd like to raise, this is my email address. It's shannon.l.ferrell@okstate.edu. One more time, that's shannon.l.ferrell@okstate.edu. Also, shameless plug time. We've actually received a grant from the Southern Risk Management Education Center to put together a employer handbook for agricultural employers. That project is currently underway. We hope to have it done by midpoint of next year. But if that's something in which you'd have an interest, shoot me an email again at this address. We'll put you on our notification list, and as soon as the handbook's prepared, we'll get you the link to where you can download a copy. Anybody have any questions? Or you had a nice big lunch during the webinar, you've now been lulled to sleep. That's what happened to the host, but other than that.
Not really.
Well, like I said, if anybody does have any questions later on, that's my email address, and Paul's included that in the chat box there for you. Thank you guys for signing up. We really appreciate you participating in the webinar today, and hopefully this information was useful to you. Back to you, Paul.
And I will just make a quick announcement. Down at the bottom of this, you'll see an evaluation. I'm assuming Shannon would like to be evaluated on how.
I'll take it. Whatever you have for me, I'll take it.
On additional topics, so please click on that. I'm going to email it out later to everyone that signed up. Like I said, there's one coming up again. Shannon's last one with us is August 6th, and there's one that we are planning without Shannon, sadly, on July 23rd from noon to 1 on FSMA, and we'll get those details sent out later. But if there are no other questions, then I will stop the recording. And
thanks everyone for participating. We appreciate you
for attending today.